Thank you, Ron. Thank you, Raj. Fun one coming up. Cause for celebration, a cause for cheering, balloon drops, and everything else. We're about to welcome onto the stage a significant amount of legal acumen and skill and strategic expertise. And our own Laura Sanders will be leading it. And this past year, as we've been talking about, the action in Congress was fits and starts. Is a bill going to pass? Is it stablecoins? Is it market structure? What's happening with NatSec, et cetera? But Congress being Congress, I think a lot of us knew that there was a very little chance of that happening. And so the action, as it often happens, was in the courts. And one of the most momentous things to happen in the history of the Blockchain Association was when a federal court in Texas vacated an SEC rule that redefined a dealer. And I think that when Laura, who's part of our legal team at Blockchain Association, comes on stage, I think we should all just scream and yell because it was a huge day for all of us. And it was led by Marissa and Laura. And it is the latest example of courts bucking the longstanding precedent of deferring to administrative agencies following the Supreme Court's decision in the Chevron case. And I believe the exact words from the SEC when this happened was, I had the quote up, something along the lines of, we will take this under advisement and figure out our next steps. Well, best of luck in the next 3 weeks in that endeavor. So coming onto the stage with Marissa are Jason Gottlieb from Morrison Cohen, Judd Littleton from Sullivan, Katherine Minarik from Uniswap, and our own Laura Sanders from the Blockchain Association.
Thank you guys so much for being here today. My name's Laura Sanders, and we are going to be discussing the SEC, securities law, and the industry's litigation outlook, as we head into 2025 and the new administration. So we have about 25 minutes and a lot to get through, so I think we'll just jump right in. Jason, so, we know at this point that Trump's nominee for SEC chair is going to be Paul Atkins. To the extent that Mr. Atkins, decides to de-escalate some of the ongoing litigation against the industry, what might that look like in practice? Is that, dismissals or settlements? And to the extent that it kind of can be predicted, when do you think the industry can expect positive movement?
Thanks, Laura. So on the SEC, you need 3 votes to dismiss a case that's already been brought. So you'd need to have that chair come in, be appointed to have those votes. That may not happen immediately after the inauguration. It typically takes a little while because you have to get all the cabinet level folks in first, and then they can move on to, I guess, a secondary tier, no matter what tier Gary may think he's in. So you have to get those folks in place. I think also you're going to want to see who will be the next enforcement director, which is going to be a big part of the strategy on the cases that aren't already pending in court, but for the cases that are sort of, under investigation, ready to go to court, because the enforcement director has delegated authority just to close those investigations if he or she chooses. So we will be waiting to see what happens when Paul comes in and when the enforcement director comes in. When they do, it's still an open question whether somebody's going to come in and just say all these cases were wrongfully brought and I'm dismissing all of them, which would be pretty bold. I mean, that doesn't usually happen, but we also don't usually have cases that push this far outside the boundaries of the law. So if I knew what was going to happen, I'd be, up over on Polymarket or Kalshi right now. I don't know, but we'll find out. I got to try to be funny. It's like 4 o'clock. You have to do something. Okay.
And Judd, the flip side of that is, we've had companies of every description and size kind of, be in active litigation against the SEC. And obviously, everyone's strategy is going to be different, but generally, how do you think those companies are going to kind of change tact in response to this sort of major shift in leadership at the SEC?
Yeah, I mean, I think the first order of business in every case that is ongoing right now is to delay, try and buy as much time as you possibly can. And I don't think we were discussing earlier, it doesn't seem like courts are really rushing cases along, and really the commission isn't really pushing at this point any of the existing litigations to get on a faster track, which is frankly surprising and could change in the next few weeks, but let's hope not. So I think the first order of business is delay, and look, I think companies are and should be trying to get meetings with the staff, meetings with the commission, try to ask them if, in light of the new policy priorities of the new administration, whether there's an appetite for dismissing a very favorable settlement, something along those lines. I agree with Jason that is, dismissal of these ongoing matters is really institutionally difficult, and I think that that's not a guarantee that just because the new commission is more favorable to the industry that means they're going to come in and dismiss everything that Gensler and folks have been doing over the past 4 years, but I do think that's where the conversation has to start, and it's a great place to be starting that conversation, and at the very least, it could, at the end of the day, like I said, lead to something that is a very favorable settlement that might not have even been imaginable during the past 4 years.
Absolutely, and I think now, the SEC poses an opportunity that it hasn't in the past to potentially, regulate our industry in a more proactive and positive way, whether that's through proposed rulemakings or, no action letters. I'm wondering, Katherine, if you had your way, what would you love the SEC to tackle first, and kind of what would that look like? And also, your views on how we as an industry can move those goals forward.
I don't know if we should go with if I had my way specifically, but I do think if you look at the cases that the SEC has brought, and I apologize, I'm losing my voice, so I hope I don't sound too terrible. But if you look at the cases that the SEC has brought in our industry, there are a lot of cases against true good faith actors, companies that have been openly, transparently, consistently operating their businesses the same way, and then all of a sudden they're told by this SEC, nope, we're gonna bring claims against you. And then the inevitable response from the company is, well, what else could we have done? And there hasn't been an answer. So that's my lead up to, well, what should this SEC do? What we can see from this litigation path is that there needs to be more dialogue with the industry, but also that there are some fundamental regulatory and legislative pieces missing. So what I think a lot of us hope for the most is that we see legislative solutions here and then true rulemaking that follows. We certainly don't just need rulemaking off decades-old legislation that is not fit for this new purpose. Under existing law, there may be space more at the edges for the SEC to be regulating the industry. But if the SEC is going to be a substantial regulator of all parts of the industry, then you would expect there to need to be real, robust market structure legislation. But that doesn't mean other rulemaking can't happen as well.
I have an idea for bridging these two things. If the SEC wants to settle some of these cases, but it doesn't want to just sort of give up and settle, thinking that's bad for institutionalism, it would send a bad message. One of the things that the SEC could offer is to say, okay, Coinbase, Kraken, et cetera, Cumberland, any of the others that they're suing on registration issues, you've been telling us, we've been saying, we want you to come in and register. You've been saying, well, we can't. All right, you have 6 months, write us a report. Tell us all the reasons you can't. Give us all of the places in the statutes, in the rules, in no action letters. Give us all of the problems that you're facing that don't allow you to register. Give us that report in 6 months. We'll compile all those reports. We'll hand them over to Congress, because Congress, who's considering the legislation, trying to figure out what they should be doing, could then get something that's a cross-section of the industry, as well as having the SEC's input on it. So that's my
Jason,
idea.
fun fact, the SEC already has that information. I think this is fairly well known in the industry, but before Coinbase got sued, and Coinbase has shared this, They spent months and months meeting with the SEC because the SEC said, would you at least talk to us? You say that you want a path to registration. Will you talk to us about it? And Coinbase said, absolutely. And they did. And they brought question after question, issue after issue, idea after idea. And at the end of those many months of Coinbase talking, the SEC essentially said, we don't know what to do here, so we're just going to sue you. So they have all that information. They could hand it right over.
So you're saying it would be an easy settlement for the companies?
No, it's not a settlement. It's a picking up that path.
Well, speaking of litigation against the SEC, I'd love to discuss some of the ongoing stuff we have going on right now, and in particular, an excuse to ask Judd about the dealer lawsuit. He was such an important part of leading the Blockchain Association and the Crypto Freedom Alliance of Texas's lawsuit against the SEC over the dealer rule, which we just won. Would love you to kind of discuss the strategy we employed in that case generally, and sort of what other litigants can take away from successfully, litigating a regulatory overreach like that one.
Yeah, I mean, as I've been saying to Ali and Marissa and Laura, you folks have been doing a lot of winning lately, and I was very happy to get a part of that in this challenge to the dealer rule. I think that the dealer rule is emblematic of, everybody knows that this administration has, made a real apparent priority out of targeting this industry very unfairly. But I think one of the other ways that has been really kind of malicious that they've proceeded is that in rules that are really not even about this industry, or at least in name not even about this industry, they kind of ignore the impact on the industry and just try to pretend that you guys are just like everybody else. And so all our laws that were enacted 90 years ago apply to you all the same way that they apply to people who deal in treasuries. And so one of those cases was this expansion of who has to register as a securities dealer. And so we brought that lawsuit, and one of the things that we did in the litigation was we tried to, there's a lot of litigation pending right now that is pretty existential about crypto and about digital assets and the status of securities. And we kind of resisted the temptation to make this challenge to the dealer rule kind of a referendum on all of that, right? Let that be settled somewhere else, work it in as part of the problem, but really keep this as a sort of bread and butter challenge under the APA, the Administrative Procedure Act, that courts are very comfortable dealing with. And, to be honest, we're kind of in the heyday of APA litigation right now with the overturning of Chevron and all the other great decisions that have been coming out of the Supreme Court. So we kept it really down the middle and really focused the arguments on, this agency is really stretching the meaning of what the term dealer has meant for 90 years, since the Depression era, to kind of achieve their own policy goals. And that's not something that under the separation of powers, agencies are allowed to do. That's something that Congress needs to do, not agencies with these old statutes. And so we made that statutory argument, and then we just kind of made this very bread and butter APA argument that was all about how different decentralized finance is from sort of traditional treasuries markets and high frequency trading, and how the agency had just ignored it, and just in response to all of these comments from you folks said, we think this is going to apply to you guys just like everybody else, when that really didn't make any sense at all. And so we really tried to keep it focused on those kinds of terms that judges are very comfortable dealing with, even if, Judge O'Connor, he is very knowledgeable about crypto now, but a lot of judges aren't. But what they're very familiar with is these kinds of APA arguments, and that's really what we did in that case, and it worked great. It worked really well. I was just saying to them, we don't know what's going to happen next. We got a great decision in it, and the notice of appeal is due on Inauguration Day, which is kind of funny. But really, I think that's, if I had to identify a takeaway from that litigation so far, and obviously we hope that it sticks and expect that it will stick, is just that courts really care about this stuff these days, especially about agencies who seem to be kind of running amok and expanding their statutory authority beyond what kind of anyone at the time the statute was enacted would have thought was a permissible, purpose that Congress had in mind.
Yeah, absolutely. And similarly, I think Jason kind of brought like a lawsuit recently against the SEC, requesting a determination that NFT art projects are not securities. And I'm curious, how you think that's going to play out now that the government side of the equation has really shifted dramatically since the initiation of the lawsuit, and what you're expecting.
I want to
there.
compliment
yes.
Jason first, because when I read that brief, I was basically jealous. I didn't write it. It was so good. So it was excellent advocacy.
He's the best.
Anytime you get to put goofy pictures into a complaint and it's actually topical, it's good. We put a pink Taylor Swift guitar picture in there. It was really fun. Jonathan Mann and Brian Fry are artists. Jonathan Mann, as some of you may know, is the Song a Day man, who's been doing one song a day every day for longer than I've been alive, I think. And Brian Fry is a law professor, but also a conceptual artist. He's got stuff in the Whitney. They were working on art projects at the time that the Stoner Cats and the Impact Theory settlements came out, and they went, wait a minute, that's pretty much exactly what we were planning to do. So they got concerned, and they're in a little bit of a different position than some big companies who need the SEC. So they said, well, let's just sue the SEC for a declaratory judgment that we are allowed to release our projects. So there's a narrow focus. Just they've got projects. These are their projects. They want a declaration that they can release these particular projects. There's obviously a lot of larger issues in the room as well. If you think about the Howey test, right, this thing from the year the ENIAC computer was invented, courts repeatedly call it a flexible test. But to be flexible doesn't mean it's flexible only in one way. It only expands. I think it needs to be contracted sometimes, given particular contexts. And when the context we're dealing with here is First Amendment protected speech, effectively the creation of art just in a digital format, I think judges should be very leery to mechanistically apply the Howey test and say these are securities because they might be able to click off the factors of the test. So we're bringing this challenge. Really, we have the very narrow ask in the case, but it's a narrow ask that may have broader implications. I think right now the SEC is going to continue jealously guarding their own right to decide their docket, so they'll push back, and we're doing a motion to dismiss briefing right now. I have no idea how the next administration might reply to it. They may say, we agree with your narrow ask, and that's it, and we'll settle the case on that basis, which would only resolve it narrowly, but might set a tone for the rest of the industry, yet to be seen.
Well, I do think that the case is a great illustration of what has gone wrong these past few years, which is that one action brought on an overly broad or vague interpretation of legislative language has enormous repercussions that don't appear to have always been thought through. And maybe they're not intentional, but then you have innocent parties, individuals, artists living with the consequences of being in the shadow of the reach of the law forever, unless they sue the government. And so I think one thing, to go back to your earlier question, that we all hope to see is less of the surprise interpretations of legislative text and more of the engagement with the public, so that there is not a surprise at the end of the day of how the law applies to your business.
It applies to artists and it applies to the software developers as well, right? If you're an artist and you make goofy little songs every day, you would have no idea that you're supposed to hire a securities lawyer before you could start selling your art. If you're two developers in your dorm room and you just came up with this brand new thing, it may not actually occur to you that you need some lawyers to help you out. And sometimes you do, but we have to be a little bit cautious about these mechanistic applications of the law.
But everybody should hire a lawyer.
So valuable.
Yes, they should. So switching gears slightly to something that is of interest to many companies in this room, and several crypto companies have been very open about the fact that they've received Wells notices from the SEC while Chair Gensler has been in that position. And I'm curious, Katherine, you've seen sort of the transition over the years of how companies have dealt with receiving a Wells notice, the process, and I think like how the companies have dealt with it in terms of publicity and aggression towards the regulator has really developed over the last few years. Curious, if you can kind of give us your thoughts on that, and then how you think things might change in the upcoming administration.
Yeah, I mean, I think traditionally when a company got a Wells notice, they might say one sentence about it and never speak about it again, and then see how the matter played out. And one thing that we've seen in the crypto industry as certain companies have gotten Wells notices is they've said, we've got a Wells notice and we want to explain how we got here and why we don't think this is right and why we've been committed to working within the bounds of the law this entire time, and here's how we've done that, and so we don't think we should be sued. I think that's a really positive thing for public dialogue, to understand what the law is and should be and how it's used as a tool by regulatory agencies. So I hope no matter what happens going forward that we do see more dialogue around Wells notices and that companies or individuals are willing to talk about them more frankly, because I think it better informs the law. I hope that it's less necessary that the company or individual's response has to be so I'm shocked and surprised. That would be nice if we weren't at that point anymore.
Yeah, absolutely. So I think we have, a lot to be optimistic about as we go, into the new administration as an industry. I am curious kind of what, existing or, remaining legal threats are still sort of catching your guys' attention at this point. I'm curious, maybe Jason, if there's a regulatory body you think that, in particular this group should, exercise caution around as we go into the new administration, where the SEC isn't maybe necessarily going to be, the most aggressive regulator in the field.
So just a very quick tour. Even if the SEC is backing off some of the registration enforcement cases, I mean, they're still going to be active in the space, particularly as more regulated institutions start pushing into it. So, don't sleep on the SEC just because they're going to be slightly better, we think. The CFTC, we always have to pay attention to, in part because the CEA is a little bit more black and white, right? You just can't offer perps to American retail without being registered in certain ways, and that's just what the law says, and that's not really a question of interpretation. So we still have to be careful about CFTC issues. Of course, and we've heard earlier today from Rebecca and Mark and others about the need to pay attention on the FinCEN and the DOJ issues in terms of money transmission laws. That's still a thing, and it's going to very much continue to be a thing as the government really prizes stopping the truly bad actors in the space and is following the money to do so. But the biggest threat may not be from the regulators, it may be on the civil side, because the change of administration, unless there's some massive change in the statutes, is not going to prevent copycats of some of the private class actions that we've seen that have been absolutely dreadful theories and have been really damaging to a lot of our friends here in the space. So that's, I think, where the real threat remains and where I think we still need to be vigilant.
Is there anything proactive you think like the industry needs to be doing on that issue in particular?
Yeah, so when we're paying attention to advocating for different statutes, let's not forget paths that can shut down some of this litigation through statutes. And this has happened before, right? In 1995 with the PSLRA, in 1998 with SLUSA, Congress took action to stem a flow of completely bogus securities class action lawsuits. I think we could do so again now. So, for example, putting into the statutes that Section 12 doesn't apply to secondary market transactions in cryptocurrencies, or even something that undercuts this Pino rule that overly broadly is a Ninth Circuit rule that overly broadly interprets solicitation and just says for a solicitation to occur, the person has to have actually been solicited, like that person, so general proclamations don't count. I think these are some statutory fixes that could really go a long way towards stemming what might otherwise be an unpleasant 4 years of additional civil litigation.
And could I just add two things? So I think that especially with how massive our federal bureaucracy is now. It's kind of like the vacuum never stays for long, right? Something else will fill it up. And so I was thinking about DOJ. It sounds like that was discussed earlier. Also the FTC. We litigate a lot against the FTC, and I think especially as these products become more widely used and more common and used by everyday people, I think we can expect to see the FTC. It's an aggressive agency, and I think we don't know for sure what the sort of position of the leadership of that agency, even under the new administration, is going to be. So I'd watch out for them. And then also the states. I mean, I think this is going to be true across all areas, is that some states are going to be really trying to step in, viewing it as their job to step in and fill the void. So you think of places like New York and California and states that may be more aligned with this outgoing administration. I think we can expect to see a lot more activity on the state regulatory level.
So we just have a couple minutes here, but just to end on a positive note, the regulators, Treasury, we just had a great ruling, Van Loon come out of the Fifth Circuit. Maybe, Judd, you can just pick up on kind of your takeaways from that case, which was so excellent, and really like the broad strokes for this group and the positives out of that case.
Yeah, another great litigation victory. It was a great opinion by Judge Willett. I think even if you don't find yourself in the habit of reading judicial opinions like I do, I suggest you read it because it's really good. It's really well done. He's a very good writer. So the sort of narrowest takeaway that's really great for you folks is that there's been this long-standing question about things like immutable smart contracts that you deploy, but then you can no longer control. How much are you, accountable, and can you be held liable for things that other people do with those products once you deploy them? And at least in this statutory context with property, you have this court saying that immutable smart contracts are not property because even if you deploy them, you can't control them anymore. And so you can't be held liable, and in this case, be under the OFAC sanctions regime for what other people do with those products. And I think the sort of broader thing, this goes back to what I was saying earlier, and it's one of my themes of the day, which is that, I really like what the court did because it says, look, we all hate or disapprove of North Korean, nuclear weapon proliferation. So that is a bad thing, right? And in a world, we would love to stop that. But you can't take statutory terms that have settled meaning like property that were adopted a long, long time ago and just have a federal agency decide, well, we'd like to kind of stretch the meaning of what that means to fit this new context to achieve this policy goal that we like. And even if a court fully agrees with that policy goal, which this opinion goes out of its way to say, look, we don't like North Korean nuclear proliferation, it's still enforcing the law and saying you can't just mold this old statute to fit new contexts and new purposes. And that's exactly what courts should be doing, and it kind of points to the ultimate lesson, which is that, Congress should do its job. And we hope that we ultimately
And all of that overstretching, it does present this real opportunity for the industry as a whole to say, here's what's been overstretched, and here is a right-fitting solution to the thing you're actually concerned about. But this right-fitting solution isn't going to do huge damage to good faith actors in an industry or well beyond as well.
Absolutely. Well, thank you guys so much for joining us. This was wonderful, and thank you, members.
Thank you for having me.
Thank you.